So, welcome to another session on corporate law, or what we call as company law, for the Institute of Chartered Accountants, Sri Lanka. And in this series of lectures, I am concentrating on the statutory, or rather the legislative provisions relating to some selected areas of corporate law, or rather the company law, mainly focusing on the Companies Act number 7 of 2007 in Sri Lanka. So on the previous occasion, I discussed about the statutory provisions, or rather the legislative provisions relating to mainly the name of a company as well as the legal status of a company, and today I am going to continue from there onwards. The lecture that is relating to the statutory provisions, the Companies Act. Now, first of all, based on what we discussed last time, I would like to take a question that was in one of the past papers of your particular subject in the exam. Now, the question is, the certificate of incorporation of ABC PLC was dated 6 January 2020. However, it was signed and issued on the 8th of January 2020. On the 6th of January 2020, the company allotted shares to Mr. Pereira. Later, Mr. Pereira came to know about the above issue. He refused to pay for the shares on the basis that the company was not in existence on the 6th of January 2020. You are required to advise ABC PLC by considering the argument made by Mr. Pereira. Now, before we start answering, I would like to recall in my previous lecture I mentioned that what is incorporation of a company is that the issuance of a certificate of incorporation. And in the issuance of a certificate of incorporation, the Registrar of Companies place a date on the incorporation certificate and place his seal with his signature. Now, that is the main effective date of the company's existence, and that should be regarded as the date of incorporation, and not merely an issuance when the issuance of the certificate has taken place physically. Now, in this question, it says that the certificate of incorporation of AB PLC, AB PLC in the sense AB is the name, PLC is for public limited company, which is a listed company. And it says it was dated, the certificate of incorporation was dated 6 January 2020. So, prima facie, or the face of it, 6th of January 2020 is the date on which the company has come into existence. Now, here, Mr. Pereira was allotted shares on the 6th of January 2020, and he made the issue that he should not pay for his shares on the basis that the certificate was physically issued by the ROC on the 8th of January 2020. What is effective date, as I mentioned earlier, is the date on which the certificate of incorporation indicates and depicts. So, it is the 6th of January 2020 that the company ABC PLC has come into existence really. So, on that day, when the company has allotted shares to Mr. Pereira, it's a valid allotment of shares. So, Mr. Pereira can't deny the fact that he has not been allotted shares properly by the company on its date of incorporation. So, the fact that he has refused to pay for the shares is baseless. And now, let us see how we should answer this particular question in a answer. So, I have written down this answer in a very comprehensive and very explicitly explaining the areas. According to section 4.1 of the Companies Act 7 of 2007, subject to the provisions of subsection 2 therein, any person or persons may apply to incorporate a company other than a company limited by guarantee by making an application for the same to the registrar in the prescribed form. So, other than company limited by guarantee, any other company under which the Companies Act of 7 of 2007 apply, one needs to apply in the prescribed form for the incorporation of such companies to the registrar of companies, and this prescribed form should be signed by each of the initial shareholders. So, each of the initial shareholders have to sign together with the following documents. So, what are the accompanying documents that you need to provide? Now, I told last time that there is a e-registration process that can be taken use of nowadays when you log into the website of the Registrar of Companies, and that you can submit all the documents pertaining to incorporation, starting from a name checking through the e-document based mode. For that, I told you last time that you need to log in through your own login name, ID and the password, and thereafter you can keep downloading the necessary documents. What are those necessary documents? Number one, a declaration stating that to the best of such person or person's knowledge, the name of the company is not identical or similar to that of an existing company. Now, first and foremost, you need to get your name registered by checking whether there is an existing name of the same nature, or that where the registrar of company has approved your name. So, once your name is approved by the registrar of companies, then you can proceed to the next step of submitting those documents. Now, first and foremost, you need to submit a declaration, right, like a letter stating that to the best of the presenter of the application and his knowledge, the name of the company is not identical or similar to that of an existing company, where you can show that you have obtained the proper approval for your name even through the e-mode. Then you need to submit the second one, articles of association of a company. Now, last time we discussed about the articles of association, I told you that it is the constitution of the company. Now, the articles of association contain several very important elements of the company's formation and its existence, such as the objects of the company, and then the rights and duties of the shareholders, the rights and duties of the directors, what sort of capital is involved in the company, how the shares are allotted in the company, what sort of shares there are in the company, are there only the ordinary shares, or are there any redeemed shares. So likewise, you need to mention all these provisions in the articles of association, and it also includes about the general meetings, resolutions of the company, then annual general meeting, extraordinary general meetings. So, all these provisions are included in the articles of association. That is actually the running document of the company, which we consider as the constitution of the company. Now, these articles of association can be found as a model set of articles in the Companies Act itself. In the first schedule to the Companies Act, it provides some model articles that can be taken use of. So, you don't need to reinvent the company articles. You can straight away take it from the first schedule. But if you so feel to do any changes or modifications, depending on your own choice, and you feel that there are specific provisions that you need to include, then you can present your own articles apart from the model articles that you can take use of. So, if different from the articles set out in the first schedule here to that the model articles, then you need to have your own set of articles and signed by each of the initial shareholders. So, the articles should be signed at the end by all the initial shareholders of the company. Then the third document that you need is the consent from each of the initial directors under section 203, that these directors initially appointed to the company undertakes the position of office of director, and that they would properly execute their functions as per the Companies Act, as well as under the Constitution, the Articles of Association of the company, to act as director of the company. So, that is called the director statement. And fourthly, consent from the initial secretary under subsection 2 of the section 221, that such secretary would act as the secretary of the company. So, now these are the important documents that you need to submit. Now, as per section 5(1) of the Companies Act, on receipt of the properly completed application, either made physically by the presenter or in the digital mode via the e-platform available in the Register of Companies website, then on receipt of the properly completed application for incorporation of the prescribed form, the registrar thereafter, once these documents are received by the presenter, the registrar shall, number one, after he receives everything, enter the particulars of the company on the register. So, the registrar shall enter the particulars of the company on the register. Thereafter, he should assign a unique number to that company as its company number, as I explained last time, a PV number. There is a serial and how to issue such a company number. So, company number is issued. So, once a company number is issued, it signifies that this particular company till its end, till its dissolution, will be using this particular company number, registration number, and it won't change. Even if the company name changes, the registration number doesn't change. And thirdly, he must issue a certificate of incorporation in prescribed form to the applicant company. So, finally, the registrar should issue a certificate of incorporation. In the prescribed form, there is a particular format of issuing the certificate of incorporation. Now, further, section 5(3) of the Companies Act states that a certificate of incorporation issued under this section in respect of any company shall be conclusive evidence of the fact that all the requirements under this act relating to the incorporation of a company have been complied with. That means the registrar is satisfied that he has obtained all the necessary documentation for this registration of this company. And it's conclusive evidence that once this certificate of incorporation is issued, it is then that all the requirements under this act relating to the incorporation of the company have been complied with, and that the company has been incorporated under this act. So, when the certificate issued, it is a conclusive evidence that the company is now incorporated on the date specified in such certificate of incorporation, on the date specified in such certificate of incorporation. So, the physical delivery of the certificate is irrelevant here. What is the effective date is the date on which that is inserted in the company's certificate of incorporation. In view of the above said, it is clear that the incorporation become effective on the day that the incorporation was dated, and not the date on which certificate was signed and issued, not the physical delivery, but the date that has been included as the date of incorporation. Therefore, the argument that Mr. Pereira raised in refusing to pay for shares cannot be upheld, as the company was in existence on 6th of January 2020, because that was the date that had been inserted in the certificate of incorporation, irrespective of the fact that the physical issuance had taken place on the 8th of January. And Mr. Pereira is required therefore to pay for the shares allotted to him, because this is a proper allotment. A similar case is found in Jubilee Cotton Mills versus Lewis, the English case. In this case, the certificate of incorporation was dated 6th of January 1923. However, it was signed and issued on the 8th of January of the same year. On the 6th of January, the company allotted shares to a person called Lewis. Later, he refused to pay for the shares on the basis that the company was not in existence on the 6th of January. Court held that the company came into an existence on the date which is stated in the certificate of incorporation, and that is the 6th of January 1923. Therefore, Lewis should pay for the shares. So, this is an identical case to this Mr. Pereira's case given in the question. So, I believe that now you understand that the physical signing or delivery of the date, issuance of the date is not relevant. It is irrelevant as against the real date that is mentioned in the certificate. Now, let us look at another question which I have not provided the full answer, but we can discuss that, where Amal and Kamal are going to incorporate a limited liability company under the Companies Act. They have decided to name the company as Ranmuthu, required as per the Companies Act. Explain how the proposed company's name should be mentioned in full. Now here, what you are required to do is not to see whether the name can be used, but what sort of a name style that this company will have. That is the question posed to you. You need to determine how this company should be named and styled finally. So now, according to the question, Amal and Kamal are going to incorporate a limited liability company under the Companies Act. Limited liability company is then, you know that it is then at the end, it is limited. It is limited liability. So it is going to be a limited company. Now then the question is, what sort of a status that this company has, whether it is a public company or a private company. Now Amal and Kamal are private individuals. There is no mentioning here in this question that there is any kind of public element involved. So therefore, obviously the term private should be inserted into the company. Now we have two names, limited is there, private is there. So private limited is what we need to include here. And what is the name of the company? Ranmuthu. So then finally, what is the style of the company name? Ranmuthu Private Limited. So this is how you need to name the company in full. The company should be named as Ranmuthu Private Limited. Now let us go back to our main discussion of the particular topics that we have selected. Now we have discussed about the articles of association. I told you expressly what are these articles of association. And I told you that it is really the constitution of a company. It is the governing document, or the running document, we say, of the company. The entire company is run through this document. So, articles of association is a very important document as relates to a company. It is like the main vein of the company's existence. Everything that is to be handled in a company should be done through the application of the Articles of Association. One must look at the Articles of Association whenever there is a concern of whether this company can do something or cannot do something. So physically, even though you don't have to refer to the Articles of Association every time when you are doing such thing, when you are doing something in the company, I mean, it is impractical, but however, you need to know that whatever you do or whatever you don't do, omission, should be in line with the Articles of Association. So Articles of Association, once they are done, either by using the model articles as I mentioned to you before, or you reinvent or you draft your own Articles of Association. Once you draft your Articles of Association or you use the model articles as per the first schedule, the next step is that in the company's registration process, as we saw before, you need to submit those Articles of Association to the Register of Companies. Now, how do you submit the Articles of Association? Submission of Articles of Association. As per section 13 of the Companies Act, the Articles of Association of a company may provide for any matter not inconsistent with the provisions of this Act. So, Articles of Association can take any form, but however, it cannot contravene with the Companies Act. It cannot go against the company law, but it can have any kind of things included in the Articles of Association. So that's why it says the Articles of Association of a company may provide for any matter not inconsistent with the provisions of this Act, other than the first schedule here too, which means that everything that is there in the model articles first schedule should be included, and in addition you can include any other specific things that you require to be in the Articles of Association for your company. And in particular, it may provide for, number one, as I told you, the objects of the company. What are the objects of the company? And you have seen in my previous discussion, I discussed about the Ashbury Railway Company Limited case, where in common law, it was held by the court that if a company acts outside its objects, or what we call act in ultra vires, the company can be held liable for breaching its objects, and therefore any act that is committed in act of ultra vires, by way of an act of ultra vires, will not be valid. Now here the objects of the company are very important, that you list down the objects. When it comes to objects, we have seen in certain companies that they use general objects, like they can do any kind of things in the company, anything and sundry things in the company they can do. So objects are very general, but also we see in certain companies that the objects are very specific, that you can do only very specific activities in this company. You can't do everything, you can't be general. There are specific acts that you can do, because the objects of the company is very specific as to doing certain things. So the objects of the company are very important to be mentioned in the Articles of Association. Then also the rights and obligations of the shareholders of the company. This is a very important element, because I told you previously also that the company's real owners are the shareholders. Even though the company has its own legal status of being a separate and distinct personality outside its members, or rather the shareholders, it has its own existence as a legal person. The main actors of a company are the shareholders who are behind the corporate veil, and they are the real owners of the company. They are the ones who have invested or investing. They are the ones who have started this company. They are the ones who are really running the company, but maybe through appointed directors. So the shareholders take a center stage in a company. So it is very important that in the Articles of Association, you mention the rights and obligations of shareholders of the company. And also thirdly, how the management and administration of the company take place. Like for example, to handle the management and administration of the company through an appointed director board, where the head of the director board is called the chairman. You can have a managing director at second place, and then you can have other types of directors. So and then the senior management and so forth. You can mention you have to mention in the Articles of Association how the management and administration of the company is going to take place, and that needs to be very much clarified in the company's articles. And about the directors' entitlements, their powers, their obligations, functions, all sorts of things need to be mentioned in these company articles. As per section 15(1), a company may at any time by special resolution adopt new articles. So now if a company wishes to adopt new articles after its incorporation, after the company is constituted, if the company requires to change or adopt new articles, amend or whatever, it should be done only by way of special resolution, because the special resolution lay a very important foundation in the company, since it's a very important decision to be made, and adopting new articles is indeed an important decision to be made, because that would change the company's outlook in a certain way. So therefore, any adoption of new articles should be done only by special resolution. You cannot adopt new articles of a company by normal general resolution. You need to have a special resolution passed for that purpose. And then if it has articles which differ from the Articles of Association set out in the first schedule, like you are going further beyond the model articles, then you need to adopt such articles as the articles of the company, adopt such articles as its articles, or alter its articles subject, however, to the conditions contained herein in the provisions of that. So whenever you want to adopt new articles, whenever you want to go further beyond the first schedule and adopt new articles, or alter the existing articles, then you need alter in the sense amend or revise the existing articles. In all these three situations, you must do so by way of passing a special resolution. You cannot otherwise validly adopt new articles or amend the existing articles and so forth of a company, unless you have taken a special resolution for that purpose. So the special resolution should be first of all styled to the particular topic of adopting new articles or going beyond the first schedule or altering its prevailing articles or whatever. You need to mention that in the special resolution. Special resolution should be tendered to the shareholders well in advance as per required by the Companies Act, and at the meeting these special resolutions need to be passed as a special resolution by the particular majority of the company in order to deposit such new articles or amendments with the register of companies, so that then the register of companies can take effect of such new or adopted articles and give it the full force of the law. As per section 15(2), where a company by a special resolution alters its articles, it shall give notice. Now this is what I told you earlier. It shall give notice of such resolution, first of all to the company, and thereafter once it is passed to the registrar. And to the registrar you have to give within 10 working days. Now generally who is doing this role? This is actually a role of the secretary of the company, who would send the company registrar a copy of the resolution that has passed these new articles, and that has to be done within 10 working days from the date on which these new articles were adopted or amendments were done. Setting out in full the text of the resolution, so you need to provide a copy of the resolution that proposed such amendment, and then the new articles as well as the passing of such resolution of any alterations to the company's articles. So these steps have to be followed in such adoption or amendment to the articles. Section 16 further states, the articles of a company shall bind the company and its shareholders as if there were a contract between the company and its shareholders. Now this statement is a very important statement, because the company's articles, as I mentioned to you earlier, is the main vein of a company, and these articles shall bind the company as a person as well as its shareholders, as if were a contract between the company and the shareholders. So the articles of association operates as a contract between the company and its shareholders. So when there is a contract likewise between the shareholders and the company, it is as per this agreement, contract, that the shareholders must act, because company as one legal person and shareholders as natural persons must comply, especially the shareholders must comply with the articles of association, because the articles of association are called forming a contract between the company and its shareholders. In particular, all money payable by any shareholder to the company under the articles shall be a debt due from that shareholder to the company. So in case that the shareholder still has to pay the share value for the shares that have been allotted to that particular shareholder, or where the shares that have been allotted to the shareholder has not been paid, then in that case the shareholder must hold that as a debt that he has towards the company. Section 17 states, where the articles of a company sets out the objects of the company, there shall be deemed to be a restriction placed by the articles in carrying on any business or activity that is not within those objects, unless the article expressly provide otherwise. So section 17 states, where the articles of a company sets out the objects of the company, there shall be deemed to be restriction placed by the articles in carrying on any business or activities. Because when the objects are laid out, as I told you earlier, either in a general manner or in a specific manner, that the shareholders must comply with the articles. There are these boundaries, not only the shareholders but also the directors. We commonly call the members of the company the shareholders and the directors, and they must comply with those objects. So they need to know that those are the defined boundaries within which they can act. They can conduct business or activity of the company, and if they conduct any activity outside those objects, then they are said to commit acts of ultra vires. They are acting out of scope. And unless the articles expressly provide for them to act likewise, then it would be all right. But however, they need to know that the objects of the articles of association, the boundaries within which the members of the company must act. Now, with that, I need to show you the provision that the shareholders, every shareholder in a company has the right to obtain a copy of the articles and keep with them. Because as section 18 says that a shareholder has a right at any time to request a company in writing for a copy of the articles of the company, and subject to subsection 2, the company shall comply with such request within 5 working days of the date of receipt and such request. So every shareholder is entitled by law to receive a copy of the articles. If a shareholder is not served with a copy of the articles, such shareholder can request for a copy, and such requests should be made in writing, requesting for the copy of the articles, and such copy shall be submitted to that shareholder within 5 working days. 5 working days. 5 working days of the company here, not the ROC, but the 5 working days of the company. If the company is working on a Saturday, Saturday is considered a working day. Obviously, Sunday would not be. However, it is subjected to a fee. So, when a shareholder requests a copy of the articles, the company can submit it within 5 days from the request, but if the company so feel that the shareholder must pay for providing the copy of the articles, then it should be done subjected to a fee. And if a copy has been previously provided within the last 6 months prior to the date of request, the company is not bound to provide it again. So if the company has provided a copy of the articles within the last 6 months to this particular shareholder who is now requesting a new copy, the company is not bound to serve such articles. But after 6 months, the company is anyway bound to submit a set of copies of the articles to a shareholder who requests for such a copy. Now, why there is provision like that, that it is a right of the shareholder to obtain a copy of the articles like every 6 months, or if the shareholder requests so? That is, there may be sometimes amendments where an existing shareholder has not properly received such amended version of the articles, if the articles have been amended or repealed, or new articles have been adopted. In such a case, to make sure that the particular shareholder is up to date as to what contains in the articles, so that like he can ask for the articles copy if he deems so, unless he has obtained a set of copies of the articles within the last 6 months. Now let us look at the effects of articles. Effects of articles. So what are the real effects of articles? Now you know that I told you the company runs its day-to-day operation in line with the articles of association, and what sort of effect that the articles will have on the company and on the shareholders and on the directors and on anyone who is dealing with that company. Now as per section 16, the articles of a company shall bind the company and its shareholders as if it were a contract between the company and the shareholders. That we know, we saw that earlier, that it is the company articles that binds the company and its shareholders, and it is considered as a contract between the company and the shareholders. As per section 17(1), where the articles of a company sets the objects of the company, there shall be deemed to be a restriction placed by the articles in carrying on business or activity that is not within those objects, unless the articles expressly provide otherwise. So a company must act within the objects so provided in the articles of association. If it acts in ultra vires, it can be said to be ineffective or invalid, not in force. But however, if the articles are quite general, then there are no specific restrictions on the company's businesses and activities that it undertakes. As per section 17(2), where the articles of a company provide for any restriction on the business or activities in which the company may engage, where the articles of a company provide for any restriction on the business or activities. If the articles of association have restricted the company's affairs or handling or doing of business or activity to certain limitations in which the company may engage, then the capacity and powers of the company shall not be affected by such restriction. I mean, to the extent that the company exists as a legal person, the company is a company that is legally represented by its own self. However, it has the capacity and the powers, but though it has to work within the scope of its objects. No act of the company, no contract, other obligation entered into by the company, and no transfer of property by or to the company shall be invalid by reason only of the fact that it was done in contravention of such restriction. Now, if there are restrictions in the objects, but the company has entered into some kind of transaction which is not allowed by the company objects, like we saw in the Ashbury Railway Company Limited case. Our statutory provision here, Article 17(2), states that by the fact that the company has operated extraneously outside the objects does not by itself constitute the fact that the company has acted in contravention of such restrictions. If that is because if the shareholders or directors can ratify such acts later, the company is then deemed to have acted within its scope. So therefore, the Companies Act in this section 17(2) says that even though certain restrictions are there with regard to business or activities, which the company may engage as per its objects, the articles, the capacity and the powers of the company shall not be affected by such restriction, and no act of the company, no contract, other obligation entered into by company, and no transfer of property or by or to the company shall be invalid by reason only of the fact that it was done in contravention of such restriction. However, as per section 17.3, nothing of section 17.2 shall affect the ability of a shareholder or director of the company to make an application to court under section 233 to restrain the company from acting in manner inconsistent with the restriction placed by the articles. So, if a company has acted in such a way beyond the restrictions imposed by the articles, any shareholder or director of the company can sue the company under section 233 to restrain the company activities in acting in a manner inconsistent with such restriction placed by the articles, unless the company has entered into a contract or other binding obligation to do so. Unless a company has entered into a contract with another party or any other binding obligation with another party, third party, to do so, or the liability of a director of a company for acting in breach of the provisions of section 188, or in the event that a director is liable towards the company for acting in breach of the provisions of section 188. So, these are the real effects of articles other than the general application of articles of association. Now, let us look at some two questions that I have taken from your syllabus. In question 1, according to the articles of association, DNI Limited, the object of the company is manufacturing and selling books. According to a recent survey, manufacturing of LED bulbs is profitable than manufacturing books. But the directors of the company are not aware of the legality of the contracts which are not authorized by the articles of association, required to advise the directors of DNI Limited. Now, this is in line with what we discussed. Generally, the company's main object here in the DNI is to manufacture and sell books. But it has now found in a recent survey that manufacturing of LED bulbs is a profitable business than manufacturing of books. Now, we know that these are completely two different types of businesses. Manufacturing and selling of books on one hand, and manufacturing and selling of LED bulbs on the other hand. So, if the particular articles of association's object is manufacturing and selling of books, obviously you cannot manufacture LED bulbs because that does not come in line with the objects of the company. But now the directors of the company are not aware of the legality of the contracts which are not authorized by the articles of association. Because I told you that the articles of association operates as a contract between the members and the company. So, you cannot do anything that is in contravention of the articles. But however, as we discuss in the effects of the articles, there are slight deviations that you can do, because by the fact that you are entering into a contract to do some other business does not itself make your acts invalid and that the company cannot do such things. But however, such matters can be ratified by the members of the company, shareholders or directors, as whatever applicable, and then make this LED bulb manufacturing as a legally allowed business of DNI. So, in order to do that, it is obviously important that the articles of association are amended in a way allowing the manufacturing of LED bulbs by D&I. So, directors, even though manufacturing of LED bulbs, if they have entered into some certain contracts, will not be that invalid as discussed in the effects of articles, but however, it is more advisable for the adoption of new articles allowing the D&I Limited to engage in the manufacturing of LED bulbs. In the second question, the Articles of Association of ABC Private Limited set out every member is entitled to cast one vote. It should be every member is entitled to cast one vote per share. One vote per share. Ranjit, the member of the company, holds 100 shares of the company. So then how many shares does Ranjit has? 100 votes. For each share, one vote, 100 shares, 100 votes. However, at a general meeting, the chairman of the meeting refused to recognize his 100 votes. Ranjit filed an action for damages on the basis of breach of contract between himself and the company, because we know that the company's articles that have provided Ranjit 100 shares and 100 votes, because one share equals one vote, then as a contract it operates to give Ranjit the opportunity to cast 100 votes. So the chairman cannot intervene there to restrict it less than 100. Ranjit filed an action for damages on the basis of breach of contract between himself and the company. Edmund, a lawyer, was appointed by the Articles of Association of the ABC Private Limited. Now, so there actually it's a break of one particular question. Require advise directors of ABC Private Limited that they cannot restrict Ranjit from using less than 100 votes, because he is so entitled, as the Articles of Association operate as a contract between the company and Ranjit as a shareholder. Second question is that Edmund, a lawyer, was appointed by the Articles of Association of ABC Private Limited as the company lawyer for life. After some time, Edmund was removed from the post. Edmund is going to file an action for damages on the basis of breach of contract by the company. So you are required to advise the directors of the company, directors of ABC Private Limited. Now here, Edmund is a lawyer appointed by Articles of Association of ABC as the company lawyer for life. He is not a shareholder. The Articles of Association only operate as a contract between the company and the shareholders. It won't operate as a contract between Edmund as a lawyer and the company. So when the Edmund was removed from the post and Edmund going to file an action for damages on the basis of breach of contract, there is no contract that exists between Edmund and the company, because it is, as I told you, the Articles of Association is only a contract between the shareholders and the company. Now, I would like to discuss another question in the same area and provide a very explicit answer as I have done before. The Articles of Association of ABC Private Limited were provided that every director shall be paid a salary of 200,000 per month. Articles of Association provide every director shall be paid a salary of 200,000 per month. Relying on this provision, Mr. Fernando became a director of the company. In his letter of appointment, his letter of appointment does not specify the salary payable. The company, in attempting to pay him a lesser amount than 200,000 per month. Now, you are required to advise Mr. Fernando by explaining the legality of the provision mentioned in the Articles of Association regarding salary payable to directors. Now, even though this matter comes within the realm of directors and the entitlement of directors, I prefer to address this question within the area of Articles of Association because it is a provision that has been referred in the Articles of Association, where Mr. Fernando as a director has been offered this job at 200,000 rupees per month as salary, director's salary, but now the company is intending to pay less than 200,000, and now Fernando is requiring your advice on the legality of the provisions mentioned in the Articles of Association. Now, how do you answer? In giving a good answer, Articles of Association is considered the primary piece of legislation of a company and is the virtual constitution of it. That you know, a company must have Articles of Association prescribing regulations for the company and be registered unless it is based on the model articles. If you use model articles, you don't need to register again, that you simply take use and effect of the model articles as you have stated in the company incorporation. But if you are going to have more than what the model articles say or you are going to modify, then of course you need to give a separate copy of such. Now, according to section 13, the Articles of Association of a company may provide for any matter not inconsistent with the provisions of this Act, Companies Act, and include matters pertaining to the management and administration of the company, as we know. The articles of a company shall bind the company as it operates as a contract between company and its shareholders, as if there were a contract between the company and its shareholders. In John Shaw and Sons Salford Limited versus Shaw, a case that we discussed earlier previously in this lecture, the Court of Appeal held that the shareholders could not circumvent the company's constitution because that is the constitution, and also it operates as a contract between the company and the shareholders. In Ashbury Railway Carriage and Iron Company versus Riche that we discussed earlier, mentioned and discussed previously, the House of Lords held that the company has pursued objects beyond its scope provided by its Memorandum of Association, and such actions are ultra vires and void. But however, as we saw in the effects of articles, for acting in such a way alone would not constitute them invalid, but however, to be further clarified if the such acts are going to be ratified. Acts of ultra vires include acting in excess of power, acting in abuse or breach of power, or acting with lack of power. A director is a person who is not disqualified of being appointed as a director under the Companies Act and acts in the capacity of an agent for the company. A director, I have told you previously also, is considered as an agent of the company. A shareholder can be a director, and anyone who does not hold shares can be appointed a director, considering his ability, experience and whatever in the area where the company is engaged with. In either capacity of being an executive director, that means a working director, or a non-executive, non-working director. A working director is generally eligible, the executive director, for a salary, unlike in a case of a non-executive director, who may be eligible only for a remuneration based on attending meetings of the directors. If a director is appointed by way of a letter of appointment, the terms of the letter will be governing provisions subject to the Articles of Associations. It's like same as a contract of employment, like a service letter that is given, like a contract of employment, appointment letter that is given. And this is should be in line with the articles. Nothing contrary to the articles shall prevail. even if they are stated in the letter, because you cannot surpass the articles even in any kind of documentation given by the company. As the articles consist the constitution of a company, as the articles consist the constitution of a company, anything contrary to the articles shall not take effect. So, anything that in contravention with the articles shall not take effect. Likewise, when a company refuses to accord anything provided by the articles, the refusal can be withheld, that the refusal is not taken. If the company wishes to act in contrary to its articles, if the company wishes to act in contrary with the articles, then only way in which it can be settled is by amending or altering the articles by special resolution, as we saw before. Articles of association shall be adopted by special resolution of the company, if need so. And where the company by special resolution alters its articles, it shall give notice of such resolution to the registrar within 10 working days with new articles, if any, as we saw before. As per section 143, a resolution shall be a special resolution when it has been passed by a majority of 75% of those shareholders entitled to vote and voting on the question, at a general meeting of which not less than 15 working days notice specifying the intention to propose the resolution as a special resolution has been duly given, provided that shareholders with not less than 85% of total voting rights at a meeting, a resolution may be proposed and passed as a special resolution at a meeting of which less than 15 working days notice being given. So, that is the way in which a special resolution needs to be passed. Subject to the provisions contained in the company's articles, a resolution in writing signed by not less than 85% of the shareholders who would be entitled to vote on that resolution at a meeting of shareholders who together hold not less than 85% of the votes entitled to be cast on that resolution shall be as valid as if it had been passed at a meeting of those shareholders. Resolution in lieu of meetings. Any matter for which special resolution is required, a special resolution is required of such resolution. The resolution shall not be effective unless notice of the intention to move it has been given to the company not less than 28 days before the date of the meeting at which it is to be moved, and the company shall give its shareholders notice of any such resolution at the same time and in the same manner as it gives notice to the meeting, or if that is not practicable, shall give them notice thereof either by advertisement in a newspaper having an appropriate circulation or in any other manner allowed by the company's articles not less than 15 working days before the date of the meeting, provided that where after notice of the intention to move such resolution has been given to the company, a meeting is called for a date 28 days or less from the date of the notice. The notice, though not given with the time required by this section, shall be deemed to have been properly given for the purposes thereof. In New British Iron Company versus Beckwith, the Articles of Association of a company provided that every director shall be paid a salary of £1,000 per month. Now, this case is very identical to the question in hand. Relying on the provisions, Beckwith became a director of the company. His written contract did not specify the salary payable, but however the company articles did so. The company attempted to pay him a lesser amount than £1,000 per month. Beckwith filed an action for damage based on breach of contract. The court held that the provisions of the articles to be treated as an implied term to his contract of employment, because he was given a contract of employment, and even though his salary was not mentioned or it was mentioned even lesser than what is mentioned in the Articles of Association. The Articles of Association's statement that a salary of £1,000 be paid per month to the director would be an implied term that will also be included in the contract of employment for Beckwith. So the court held that the provisions in this article be treated as an implied term of his contract of employment. Therefore, the company cannot pay him a lesser amount than £1,000 per month. So that's how you need to arrive at the conclusion. Now, why I discuss about the resolution is to show how such resolution should be made if in case you need to alter or adopt new amendments to the constitution or the articles through a special resolution. Sometimes if you run out of time in answering the question, you may not write about this, how to make an effective special resolution in this case, but you can straight away go into the main area that we discuss about the contravention with the articles of this contract of employment, as the articles operate as implied terms to the contract of employment in that respect. Now, let us look at the articles of a private company. Now, the Companies Act number 7 of 2007 very specifically have provisions with regard to articles of a private company. How should or what extra things that the articles of a private company must contain. Now, as per section 27 of the Companies Act, the articles of a private company shall include provisions which, number 1, prohibit the company from offering shares or other security issued by the company to the public. So, the articles of association of a private company must not have any provision allowing such company to issue its shares or securities to the public. So, it must or it shall prohibit the company from offering shares or other securities issued by the company to the public. And secondly, the limit the number of its shareholders to 50. So, the maximum number of shareholders should be limited to 50. So, no private company, no private limited company or private company shall have shareholders over the number of 50 or not more than 50, and not including shareholders 50 in the sense private people, not including however shareholders who are employees of the company, because sometimes the companies give shares out of its profits to the employees of the company. There are some companies that issue shareholding to the company. There is a rationale here, that is to let the employees of the company believe that they are also having a part ownership to the company, so that they would be very efficient in their working, because they feel that it's their own company, it's their own asset. So, some companies offer shares to employees, but these are shares that are not eligible with special entitlements, but probably some selected category of shareholding that have certain limited rights for its shareholders. So, private company can have a maximum of 50 personnel, either private natural people or private corporate entities together, 50. But that 50 shall not inclusive of the employees of the company who have been allotted shares, or former employees of the company who become shareholders of the company while being employees of such companies, that after their retirement or after they leave the company, they still retain the shares, and such shareholders are also not considered as falling within this limitation, maximum limitation of 50, and who have continued to be shareholders after ceasing to be employees of the company. So, private companies have very specific provisions in their and shall be included in these articles as to those respects, what we discussed as A and B. As per section 28(1), if a private company alters its articles, if a private company alters its articles in such a way that the articles no longer comply with the requirements of section 27 that we discussed earlier, then if a private company alters its articles in such a way that the articles no longer comply with the requirements of section 27, the section that we discussed earlier, what will happen? The company shall cease to be a private company. The company shall cease to be a private company. And provisions of section 30 and 31 shall cease to apply as with regard to a private company. So, section 30 and 31 shall cease to apply to that company, and the company shall be deemed to have changed its name in accordance with section 11, that it will no longer be anything like private limited company, for example, because the nature of the company has now changed. It is no longer considered to be a private company. That's the reason. As per section 28(3) of the Companies Act, the court may determine that provisions of subsection 2 shall not apply, earlier subsection that we discussed, shall not apply in respect of failure by a private company for a failure where it is satisfied that the failure to comply was due to inadvertence. If inadvertently this particular private company has effected something like section 28(2), then of course the court may not determine, may determine that it has not contravened with subsection 2, or the failure to comply has been rectified, or if the failure to comply with section 27 have been later rectified by the directors or shareholders, members, or in all the circumstances of the case, here it is just and equitable to reach such determination. In all such circumstances of the case, it is just and equitable to reach such determination. That means that the reason why they have committed such an act as being prohibited is just and equitable to reach such determination. So, in any of these three circumstances, the private company that acts in contravention with section 27 would be not subjected to section 28(2) and considered to be a failure by a private company, because if such company can satisfy the court that it had acted in either of these A, B or C, then in that case that company can be exempted from such liability. Constituting a company limited by guarantee. Now let us look at, earlier we looked at what are the specific articles that needs to be included in a private company. Now let us look at how to constitute a limited liability company limited by guarantee, company limited by guarantee. This is actually a very special case, very special type of companies that fall within the meaning of guarantee limited. So therefore, there are very specific articles that apply in the constituting of a company limited by guarantee. Now as per section 32, any two or more persons may apply to form a company limited by a guarantee. So the minimum number of persons required to apply with the register of company, the registration or incorporation of a company limited by guarantee is two or more persons. So no single shareholder situation can exist there. You need to have two or more persons. By making an application to the registrar for the same in the prescribed form of constituting a company limited by guarantee, signed by each of the initial members, likewise in a normal case, together with the following documents. So apart from what we discussed previously, the limited guarantee companies should submit the articles of association of the company, a consent under section 203 for each of the initial directors to act as directors of the company, and a consent under section 221 for the initial secretary to act as secretary of this company. So you need to fulfill those three elements in applying for a registration of a company limited by guarantee. As per section 34(1) of the Companies Act, where the registrar is satisfied that an association about to be formed as a company limited by guarantee is to be formed for the promoting of commerce, especially social service organizations that intend to have a company style existence by way of a guarantee limited, then of course when their objects are to promote commerce, art, science, religion, charity, sport or any other useful object, and intends to apply its profits, whatever it raises, if any, or other income in promoting its objects, and to prohibit the payment of any dividends to its members, then the registrar may by license direct that the association be registered as a company limited by guarantee. So any association of such nature can request from the registrar to register such organization as a company limited by guarantee, and he can do so. But however, he should not add the word limited to its name. In such a case, not with regard to all the guarantee limited companies, but especially with regard to these types of charity based or community based organizations that promote commerce, art, science, religion, charity, sport or any other useful object. The registrar must not include the word limited to its name, and the association may be registered accordingly and shall on registration enjoy all the privileges and subject to the provisions of this section, be subject to all the obligations of a limited company, which is very much similar that its existence as a limited company, though the word limited will not be given by the registrar for registration of such a organization as a guarantee company. Now let us look at the company contracts. the company contracts. Company contracts. Now I told you that a constitution or the articles of association of a company operates as a contract between shareholders and the company. But here, as company contracts, what we are discussing is not that. What we are discussing here are the contracts that the company enters with other parties, with a third party. The company enters into contracts in conducting various kinds of businesses and activities that the company is deemed to enter into. The transactions, the companies enter into various kinds of contracts, and these are called company contracts. Depending on the type of contract, depending on the type of businesses or activities that this company is to take effect, the company can enter into various kinds of contracts with its customers, with its third parties, with other people, right? Now just imagine a situation. Now, if you imagine a kind of bank business. Now bank enters into various kinds of contracts with its customers, such as maintaining of accounts, savings or current or whatever, fixed deposits. Then providing of credit card facilities, providing of loan facilities, and so forth. And the company, such company, enters into various kinds of contracts with its customers. Now if you look at some other kind of a company, such as a company that manufacture goods and sell, distribute, export, in all those areas, such companies enter into different kinds of contracts with different kinds of personalities, be natural persons or artificial persons like companies again, corporate entities, and various contracts of different contents for different subject matters. So therefore, the area or the realm of company contracts are very important in company law, because what is very important there is the capacity of the company to contract. Capacity of the company to contract. It is by the use of the capacity to contract that the particular company enters into such any kind of contract with a third party or with a customer, with an outsider that deals with the company. So company contracts form a very important element as to its day-to-day operations. Now as per section 19(1), a contract or other enforceable obligation may be entered into by a company as follows. A contract or other enforceable obligation may be entered into by a company as follows. An obligation which, if entered into by a natural person, is required by law to be in writing, signed by that person, and be notarially attested, may be entered into on behalf of the company in writing, signed under the name of the company. Now, an obligation that the company has, which if entered into, represented by the company by a natural person, if a natural person is entering into a contract with somebody outside on behalf of the company, then it is required by law to be in writing, and signed by that person who enters into that contract on behalf of the company, and be notarially attested. That means it should be entered in front of a notary public, and the notary public must give an attestation that such agreement was entered between the company and the outside person, may be entered into on behalf of the company in writing, signed under the name of the company. And the person entering into the contract is entering into that contract on behalf of the company in writing, signed under the name of the company. It is in the name of the company that he is signing, because the company is an artificial person. The company cannot do anything. It is a natural person who has to do that. So therefore, such natural person representing the company and acting on behalf of the company sign such a contract, then such contracts are valid only if two directors of the company sign, or if there are only one director, by that director, or if the articles of the company so provide, by any other person or class of persons, or one or more attorneys appointed by the company and be notarially executed. So company contracts that are entered with outsiders, the contract is to govern the company. As long as the contract is valid and enforceable, the contract is to bind the company. So binding the company is very crucial for the company. So therefore, if a contract is entered on behalf of the company, I am not talking about a day-to-day type of business activity contracts. These are very important contracts for which the company becomes liable and obliged. In such a situation, such contracts need to be signed by a natural person, because the company as an artificial person can't sign or do any act. So it has to be a natural person who signed before a notary and attested by the such notary as to the execution of such contract. And now, who are these natural persons who can sign on behalf of a company? It is the persons who are doing the general day-to-day administration management of the company. Who are they? The directors. So obviously, such contract on behalf of a company must be signed if the company has more than one director, and if the articles say that a company contract be valid only if two directors sign, then these two directors of the company must sign. If there will be only one director in that company, then that director must sign. Now, other than these directors, if the articles of the company so provide for some other person in the company, giving the authority for him or her to sign, then by that any other person who can sign. Or it could be a class of persons, not one person, but some class of persons, such as some 2 or 3 members of the senior management of the company. But if they are authorized to sign such contracts as per the articles of association of the company. And in every such case, such contracts are to be notarially executed. What do you mean by notarially executed? That the parties must sign before a notary public together with maybe 2 witnesses at least be present at the time of signing, together and in front of them, and the notary public provides an attestation to the contract that this particular contract was signed before me by the particular persons on behalf of the company and in front of the witnesses who have signed here. In each person's presence, and this notary public must give such attestation in the execution of such contract. Then only such company contracts become legally valid. Now, as I mentioned earlier, we are not talking about ordinary contracts of companies. These are company contracts, contracts that we refer as company contracts. Whenever a company contract is signed, it should be done in such manner. It should be done in such manner. Company contract by which the company obliges itself to do something, or the company obtains certain rights to do something out of that contract, in whatever circumstance. These are not ordinary day-to-day operations, but where the company enters into some important decision making, upon decision making, to effect certain matters or doing certain transactions or activities by way of contracts. As per section 19(1)(b), an obligation which, if entered into by natural person, is required by law to be in writing and signed by that person, may be entered into on behalf of a company in writing, signed by a person acting under the company's express and implied authority. And also further, such person to be entitled to act on behalf of the company and enter into such contracts on behalf of the company, then that person must have the company's express or implied authority to do so. It's not just a normal person who can do. It is a person who is so eligible as per company's express or implied authority, having express or implied authority to do so, can enter into such contracts by in writing, sign in that way. As per section 19(1)(c), an obligation for and on behalf of the company, which if entered into by a natural person, is not required by law to be in writing. If the law does not require any obligation of a company to be in writing, then may be entered into on behalf of the company in writing or orally by person acting under the company's express or implied authority. So, an obligation which if entered into by natural person is not required. The previous case was when the law required to be in writing. If the law requires, if law does not require to be in writing, then it may be entered into on behalf of the company either in writing or orally, whatever they want, by a person of the company that has the authority of the companies in express or implied manner. Now, what do you mean by express or implied? Express in the means that the company has expressly allowed that person to represent itself. Express. Express could be by word or by writing, whatever. but there is expression for that person to represent the company. Implied in the sense that the opposite of being expressed, that the company may impliedly allow a person to act for itself. In such a situation, that company said to have provided implied authority to such person to act on behalf of the company, and that person can enter into such contract or obligation likewise by using this express or implied authority. So in first class in 19(1)(a) we discuss about any contract or other enforceable obligation. Secondly, in section 19(1)(b) we discuss about an obligation that is to be entered which is required by law to be in writing, and how to do it. And under section 19(1)(c), it's an obligation which a natural person in a company is not required by law to enter into such contract in writing, can do so by either writing or orally, but with company's express or implied authority. So express or implied authority is a must. This is very important, because at the end of the day, the company being an artificial person may obtain rights or be obliged in duty in whatever manner. The company is answerable. That is why company contracts need to be in writing, signed by authorized people, notarially executed. But further, if it's not a contract but only an obligation, then if required by law in writing, then to be in writing and signed by person acting under the company's express or implied authority. If an obligation which the law does not require to be in writing, then it can be done either in writing or orally also, but by a person acting under the company's express or implied authority. Otherwise, none of these contracts or obligations relating to a company will be valid in law, will be legally valid. So that is why the Companies Act in this section 19 has made proviso in relation to company contracts and how to enter into company contracts and how to give the effect to company contracts. Now, companies can be represented by attorneys or lawyers. Now we say company lawyer. So likewise, company attorneys are people who represent the company as an attorney. Now earlier in a question also we saw a lawyer was appointed for life to be the attorney of the company. Likewise, a company generally appoints an attorney, but it is not mandatory, like the appointment of a secretary is mandatory. Appointment of secretary is mandatory, but appointing an attorney is not mandatory, but some companies do appoint attorneys. But if such company attorneys are appointed, as per section 20 subsection 1, a company may by an instrument in writing executed in accordance with provisions of section 19 appoint a person as its attorney, either generally or in relation to a specified matter. Now what is important here is that if the company intends to appoint an attorney as per section 20 subsection 1, it must do so in accordance with the previous section that we discussed in company contracts. As per provisions of section 19, a contract, obligation required to be in writing by law, or an obligation where the law does not require it to be in writing, whatever. Appoint a person as its attorney either generally or in relation to a specified matter. It can be a general attorney or for a specified matter for a company to appoint an attorney. Now, in courts, what we generally see is that whenever a company is filing a case, or whenever a company is subjected to a case, if a company is filing a case, the company is the plaintiff. If the company is being sued, then the company is the defendant. In whatever way. Now, a natural person can straight away go to court and appear by himself. But a company can't do, because company is an artificial person. So, company has to be represented. So, the company has to be represented by its own attorney. Then in that case, the company must give the power for such attorney to appear for itself. So, when such a appointment is done, it can be for the general, all types of actions that a company is a party, either plaintiff or defendant. The company can give authority to its company attorney, or in a specified manner for a specific matter, the company can appoint a person as attorney at law. And section 20 subsection 2 states that any act of the attorney so appointed by a company carried out in accordance with the instrument referred in subsection 121 shall be binding on the company. So, which means that whatever the attorney so appointed by the company does, it would have effect on the company, and the company will be liable for whatever that attorney is doing. If the attorney takes rights for the company can attain the rights. If attorney takes liability, the company has to take that liability. So, whatever that company attorney is doing shall be binding on the company once a company appoints an attorney, either generally or in specified matters. Now, let us look at the authority of directors. Authority of directors in relation to an obligation entered into by a company. As per section 21, a company or a guarantor of an obligation of the company, or any person claiming under the company, may not assert against a person dealing with that company or with any person who has acquired rights from the company, unless that person has, or by virtue of that person's position, with or relationship to the company, or to have knowledge to the contrary, that the articles of the company have not been complied with, or the persons named in the most recent notice filed under section 223 or the annual return delivered under section 131 of this act are not the directors of the secretary of the company, as the case may be, or the persons named in the most recent notice filed under section 223 or the annual return delivered under section 131 of this act are not directors or secretaries of the company, as the case may be, or does not have authority to exercise the powers and perform the duties that are customary in the business of the company, or are normal for a director, officer or agent of the company carrying on business of the kind carried on by that company, or a document issued by any director, secretary of the company, or by any officer or agent with actual or normal authority to issue the document is not valid or genuine. Is not valid or genuine. Only the directors have the authority to act for the company. Now on the next day I will be dealing with the director's powers and acts in a company. So today I am taking finally the authority of directors. Now who is a director? As I told you earlier, director is a person appointed to attend the management and administration in a company. There are certain qualifications identified by the Companies Act for anyone to be appointed a director, and there are also disqualifications of persons who may not act as directors of a company. Directors are usually considered as agents of the company. They are not agents of the shareholders, but they are agents of the company. Whatever the directors do in wrong, the company becomes vicariously liable because directors represent the company. So whatever the wrong that the directors do, the company has to take the blame. It is only in circumstance where the court allows the lifting of the corporate veil and find the real perpetrators behind a wrongful act, where the directors may become personally liable. But unless such a lifting of the veil, corporate veil, take place, the company itself is liable. That is why providing the authority to directors to act on behalf of a company is said to be a power conferred as an authority by the company on the directors to act for the company, and whatever the wrongful acts the director or directors do, the company becomes liable. So as per section 21, a company or a guarantor of an obligation of the company or any person claiming under the company may not assert against a person dealing with that company or with any person who has acquired rights from the company, unless that person has, or by virtue of that person's position with or relationship of the company, ought to have knowledge of the contrary, that they had acted very innocently, in a very bona fide manner, in good faith, that the articles of company have not been complied with. If the articles have not been complied with, the persons named in the most recent notice as directors or secretary of the company, as the case may be, or the persons named in the most recent notice are not directors or secretary of the company, as the case may be, or does not have authority to exercise powers and perform the duties that are customary in the business of the company or are normal for a director, officer or agent of a company carrying on business of this kind, carried on that by that company, or a document issued by any director, secretary of the company, or by any officer or agent with actual or normal authority to issue the document, it is not valid or genuine if such director has or secretary has misused its authority and has acted in ultra vires gone beyond its powers, gone beyond out of its scope, but that would not affect a third party dealing in good faith with the company in some business or activity the company is involved. The company would be liable towards the third party unless that third party had acted without good faith or with the knowledge that such director or secretary has no authority to do such act. And only in that case then the company will not take that liability or responsibility, but in any other case where the authority has been misused by directors or secretaries in doing such transactions, the company is liable. But if the third party has acted in a wrongful manner with knowledge, then such transaction would not be valid or genuine. So that's about the way in which company directors and secretaries must act for the due obligation towards the company, because the company, end of the day, again to say, it's an artificial person. Whatever the company does are conducted by its directors as agents of the company, and if they have wrongfully acted with third parties, the company will become liable to the third parties unless the third parties had acted without good faith or with knowledge that they are acting in such bad way. There is also a very interesting case law that we have discussed in this area, that in case the officers of the company act in such a manner, wrongful manner, then a third party dealing with the company in good faith and without knowledge of such wrongful manner in which the directors are acting, the third party will have cause of action against the company, and third party cannot be held liable. The third party will obtain whatever the rights it is entitled to in such a scenario. So next day I will be dealing with the directors and the areas of directors under the statutory law. So today we discussed about the statutory and legislative provisions relating to the articles of association in a company and the company's competence in entering into contracts and other obligations. And what happens if a company through its officers have entered into wrongful type of business activity, thereby making the company liable towards the third parties who transact with the companies by way of contracts, and how company contracts have to be entered in legally valid form. So we will continue our lectures on the next day in same line, discussing the statutory and legislative provisions of Companies Act 7 of 2007 relating to corporate law, what we commonly call as company law in Sri Lanka. Thank you very much for listening.